one of the significant areas we'll be covering here today. All right, we're going to be moving into the specific materials. And we'll start first with restraint and seclusion. Okay, and Mr. Lund will be starting here.
Good morning. I'd first like to review our agenda. We will review identified areas of high noncompliance, review how noncompliance is identified using the student compliance monitoring tool. We will define restraint. We will define seclusion. We will review the DCMR regulatory requirements as it relates to identified areas of noncompliance. And at the end, there will be an opportunity for discussion. If you take a look at the chart in front of you, you can see that the noncompliance rates of written restraint incident report contains all required information. 2012 to 2013 was 67%. 2013-14 school year, 64% noncompliance. And 2014 to 2015, thus far, noncompliance is 47%. Please keep in mind that that 47% is only through February and does not include the whole year. Written seclusion incident report contains all required information for 2012 and 2013 as well as 2013 and 14. That data was not collected separately. However, for thus far in the 2014-2015, there's 100% non-compliance. That means we've identified something within the report that is missing. Post-restraint IEP follow-up, that data was not collected in 2013. In 2013-14, there was 88% non-compliance, and that number held basically flat this year, the 2014-2015, again at 88%. And finally, post-seclusion IEP follow-up, 2012, the data was not collected. 2013 and 14, the data was not collected separately, and identified non-compliance in 2014-2015 is 100%.
So here, really the take-home message, what we're talking about is the most significant forms of intervention that can be implemented on a student who is in crisis. And in terms of OSSI's concern for student safety and for staff safety, these numbers are pretty significant and concerning. So what a goal here today is to be able to not only identify the rates of noncompliance, but also to be able to ensure that we can provide some guidance around increasing the level of compliance. Sometimes we're clear that there's information that doesn't make it into incident reports that if we were aware of, we would be able to make other determinations where there is more compliant practice. But really the take-home message is if we don't see it in an incident report, if we don't see it in terms of SEDS documentation, we're not able to apply it to determine compliant practice. So as we go through each of these areas, we will be covering the requirements. They're covered in the regulations, which we've included links at the end of the presentation for. These requirements are found in our regs, and we will go over them as we continue.
To give you an idea of where noncompliance is developed from, I want to just briefly go through our student compliance monitoring tool. You all have access to this tool. It includes the area, the item number, the legal reference where appropriate, the item response criteria, and potential corrective action. Next, we'd like to define the physical restraint as from the DCMR, Section A 2899. Restraint is defined as the use of bodily force to limit a student's freedom of movement. The big takeaway from this is it is any bodily force used to limit any student's movement. In terms of the regulations, the use of physical restraint is prohibited except in emergency circumstances. The restraint must be included in the IEP to address specific behaviors identified under defined circumstances. The intervention is necessary to protect the student and other persons from imminent serious harm, and all less intrusive physical interventions must have failed or have been determined inappropriate at that time. So physical restraint must be an emergency situation.
One of the things that we've seen in reviewing incident reports over the last couple of years is that there are instances where there's not enough information in the incident report to determine that it was an emergency circumstance, that there was no real description to be able to determine that the student was in imminent harm or that others were in imminent harm. And, you know, again, we're concerned about, you know, student safety in those kinds of situations. So it really is imperative to be able to make sure that the documentation supports the justification for, you know, in this case, a physical restraint, or later on it will be for a seclusion.
The restraint shall be applied only by trained and certified staff, trained in the appropriate use of the specific techniques. There are any number of different programs that are used throughout non-public schools. The key here is that staff must be trained and certified for use of the restraint techniques. Physical restraints shall be limited to the use of reasonable force for the shortest period of time to protect the student from imminent serious harm. What we need to see is that as soon as a child or the student is calm, they have de-escalated, that they are released from the restraint immediately. During that time of the restraint, the student needs to be provided with an explanation of the behavior, and there needs to be a member of the staff observing the student during the entire duration of the use of the restraint. This is to protect the student from any potential breathing difficulties or distress that may not be noticed by those who are performing the restraint. Physical restraint is prohibited as a means of punishment, property destruction. Students' refusal to comply with school program, rule, or language does not constitute an imminent threat or serious physical harm.
So property destruction here is one of the significant areas where we see, you know, areas where we're concerned about practice. Again, you know, property destruction in and of itself, as per the regulation, is not a sufficient justification for the implementation of a restraint. Being able to demonstrate that that property destruction puts a student or another staff member or another student in immediate danger really is the key to being able to demonstrate compliant practice in this area.
And it's important to make sure that is documented in the reports. What we don't see is that the property destruction now became a danger to the student or to the staff.
And an example of that might be the student threw a phone and then was restrained in a double arm bar. So it's not clear that was the phone thrown at another individual. Was there any kind of imminent danger? The student could have thrown the phone into the corner of the room where there was nobody occupying the space. So again, the details and the detail really provides the justification for the use of a restraint or a seclusion in that kind of a situation.
No physical restraint shall be administered if the student has a medical or psychological condition contradictory to the restraint. If a student has a medical condition, significant asthma, for example, and placing that student in restraint is going to restrict that student's breathing, then restraint may not be applied. If at any point a staff member notices that the student is struggling to breathe, they're at risk of imminent danger to themselves or harm, the restraint must be released immediately. The use of restraint practices with a student whom non-public education school or program knows has been sexually or physically abused is prohibited. And the chemical restraint must only be used when it's determined medically necessary. Both mechanical and prone restraints are prohibited and shall be grounds for denying or revoking a certificate of approval. Next, I'd like to define seclusion as DCMR Section A 2899.
One of the things we recognize here, as Mr. Lund will define seclusion according to our regulations, we have a number of schools who serve our students who are not physically located in the District of Columbia. And what's important to understand is when it comes to interventions with our students, the lens that we look at it, and we expect the non-public to look at it, is through the lens of what the DCMR requirements stipulate. So, schools that serve multiple jurisdictions, certainly those will be challenges for, those schools serving students coming from a number of different jurisdictions. But again, the take-home message here is that our regulations apply for our students.
Seclusion is the involuntary confinement of a student, alone in a room or in an area where he or she is physically prevented from leaving, or from which a student believes he or she may not leave. So it's not just that they are physically prevented, but if the child believes or the student believes that they cannot leave that room, then that is considered seclusion. And whether or not the door is locked.
So we have a couple of questions. We'll be covering the elements that are the required information in written incident reports in just a few minutes. So we'll get to that. There's also a question about expanding on the issue of restraints used with students with a history of abuse. This is an area that, we recognize that many of our students have had, various histories that may include physical or sexual abuse. And, at times those students end up in crisis in ways in which, there may be immediate safety issues with themselves or with regard to others around them. We recognize this, and, while the requirements are explicit in terms of the prohibition for these kinds of restraints, these are situations, again, that we recognize happen. If you have specific areas of concern about specific students, we're happy to have kind of, individual conversations about that. But, really regulations are explicit in this area, but like I said, that's a conversation that makes more sense to have in individual circumstances.
A non-public special education school or program shall not use any form of seclusion on a District of Columbia student unless it is defined as an emergency, as defined in section A 2816.1. The space that a child or a student is secluded in must be free of objects, fixtures with which the student could inflict bodily harm. There must be adequate view of the student at all times, and the room must have adequate lighting, ventilation, and appropriate temperature controls. Seclusion shall only be applied by trained personnel with the use of the specific techniques and the knowledge of regulatory provisions and any other guidance issued by OSSI. The student must be monitored at least every 10 minutes, and no seclusion shall last longer than 1 hour.
And this is an area that we, again, recognize that other states have other timelines or other time limits based upon students' age. But again, for us and district students, what's important is 1 hour is the maximum amount of time for seclusion.
If the space happens to have a locking mechanism, it can only be engaged when held by a person, or if it is, must have an electronic disengagement and automatically release if the building's fire alarm system is activated. This makes sure that the student that is secluded can escape the room in the event of a building emergency. At this point, I'd like to review the restraint and seclusion reporting. There are a number of areas here that schools do well, and we will try to identify those areas that we see the majority of non-compliance. The list consists of the student's name, the date of the incident, the beginning and ending times of the incident, and the beginning ending times of the restraint or seclusion. These are two different times. The beginning time of the incident should contain within it the beginning and ending times of the restraint or seclusion, a description of relevant events leading up to the incident, a description of any interventions used prior to the implementation of the restraint or seclusion, a log of the events during seclusion and restraint, including restraint technique used, a description of staff or student injuries or property damage, signatures of the staff that participated, and a description of a short-term plan approach to address the student's behavior in the future.
So one of the things I should have said before, you all should just recognize. So you'll see here at the bottom, 5 DCMR, Section A 2820.1. This is the specific location within the Certificate of Approval regulations for the incident report documentation requirement. This convention, we have all the citations for the relevant regulations on the bottom of each of the respective pages. So, you should be able to use that to access specific information regarding anything that we're covering here today.
Log of events. The events must be observable and should be documented in short intervals. Common observable events may be muscles were relaxing, willing to follow directions, aggressive behavior decreased. Increasing observable events include cursing, throwing objects, spitting, kicking, trying to escape.
And part of what's important here, I'm a clinical psychologist by training, and as I review these incident reports, and thinking about it not just from a compliance perspective, but also from a treatment perspective and an intervention perspective, being able to look at both in terms of the antecedent events, the attempts at de-escalation strategies prior to a restraint or seclusion, and also in this log of events, once a student is restrained or secluded, provides a lot of really rich data to be able to use to determine kind of what was effective in the behavior support plan and the intervention plan, and what wasn't effective for future instances where a student may have increasing difficulties. So again, this is not just about being able to kind of look from a paper perspective and see what we're looking for as per the regulations, but it also provides, like I said, a lot of rich clinical data to be used, and the expectation is that schools are using it in ways to support students, but also to document that support.
Short-term planned approach. A description of the short-term planned approach to addressing the student's behavior in the future. The student spoke to the licensed clinical social worker or processed with staff is not a planned approach. What they discussed or what Johnny will do when he gets agitated is a plan. For example, when Johnny becomes frustrated with an assignment, he will ask for a timeout break or request teacher or peer assistance. That helps Johnny deal with the frustration, and that identifies to us and to you what you have done to address the behaviors in the future. And this can also be used when speaking with the student and getting an understanding of what has worked and what hasn't worked. And it's a great tool for tracking those specific conversations to bring back to the table with the student after the crisis. The written incident report shall be prepared for each individual incident following restraint and seclusion and placed within the student's permanent file in 24 hours of the incident. And for the District of Columbia, that is SEDS. And a written copy of the report shall be sent within 1 business day to the parent and to the sending LEA or any other District of Columbia agency.
So here, again, some of the things that we've been seeing, the documentation and the follow-up for restraint and seclusion incidents is really an area that's been concerning. Oftentimes we see most frequently that non-public schools are notifying parents that their child has been restrained or secluded, and the most common form of that communication has been by phone, and that's great, and the parent certainly is made aware. But again, the written requirement in the regulations requires that a copy of that written report actually goes home to the parent. They're provided a copy within 1 business day of the incident. Also, the LEA is provided a copy. In general, in terms of our compliance standard, if a copy is uploaded into SEDS within 1 business day, the non-public is able to demonstrate adherence to that regulation, because the expectation is that the LEA should be regularly reviewing SEDS for that information. It's also important to note here, if a student has another agency that has been involved in the student's placement, for example, Court Social Services, DYRS, or CFSA, a copy of the written incident report should also be sent to them. And again, these are things that we're looking for, not just because the regulations require it, but to ensure that the relevant stakeholders who can participate and provide input into looking at a student's behavior management program are made aware of it so that they can begin to have that contribution. What we get is that in a lot of cases there are clinical team meetings, rounds, other kinds of treatment team meetings that occur where incidents are being discussed. What's important is that documentation makes it back into students' IEP files to demonstrate what we know is happening in a lot of cases is that teams are actively monitoring kind of students' programs and being able to kind of make tweaks to behavioral intervention plans, develop or implement FBAs, or even implement a BIP. but again, it's not making it in terms of the IEP process.
It's also important to just document the form of communication in a log so that it can be presented if needed. Notification requirements. This is really just a quick review of the previous slide. Who? Parents, sending LEA, other agencies, DYRS, CFSA, CSS. Where and when needs to be placed in the student's file in 24 hours. Copies distributed in 1 business day. And document parent LEA notification. Restraint, seclusion, follow-up. The IEP team needs to meet within 10 days of the incident to consider FBA and BIP and to discuss non-physical and less restrictive strategies. If the student has a BIP in place, the IEP team shall review and revise it as appropriate. Schools, and we have seen a significant number of noncompliance in conducting an IEP meeting each time there is a restraint. It's important to do this to identify what can be done to help prevent future restraints and future seclusions from happening. And the best way to do that is to review the data and make adjustments to a BIP and implement a new one if needed.
So let's just kind of break this down in terms of, kind of the practical considerations here. So IEP teams shall be meeting within 10 days of the incident to consider the need. So, if there's a BIP that's already in place and the IEP team has implemented that IEP, documentation should include, that there may be no justification for modifying the BIP. It's just been in place for a few months or a few weeks, or that there is a need to modify the BIP. If there has not been an FBA, part of the documentation that we would expect to see from those IEP team meetings would be that an FBA will be developed and then potentially a subsequent BIP implemented. Again, what's important here is to be able to document ongoing consideration of student incidents and student behaviors and the attempted interventions as students continue potentially to have restraint or seclusion incidents. So, what we're not seeing is that kind of ongoing consideration in terms of the documentation. We're not saying that it's not happening. We're very aware in a lot of instances it is, but the IEP documentation in SEDS doesn't really support that. So as clinical team meetings happen, as rounds happen where those issues are discussed, again, it's really being able to provide that information in the SEDS context.
Non-physical interventions. This really answers what did the staff do to de-escalate the student's behavior before the restraint or seclusion was implemented. De-escalation techniques include active listening, directive statements, proximity controls, changing the student's location, removing the audience or target. The key here is to utilize the specialized training that staff has received to de-escalate situations prior to the need of a restraint or seclusion. The use of de-escalation techniques should demonstrate the specialized knowledge that staff has in comparison to someone who is intervening off the street. I'd like to share this thought. If your child was in an emotional crisis, would you want someone physically restraining them before all other less intrusive de-escalation techniques were attempted? And lastly, there is a copy of our incident report quality checklist. This was taken specifically and directly from the regulations, and it identifies all of the areas. It is a great tool to use to ensure that all the items that the district requires are completed on each individual restraint and seclusion report.
Okay, so we're to the end of this section in terms of the presented material. We have a few questions, and we'll go back and try to answer those questions. Have there been any recent changes to the reported aspect of the regulations? It is understood that some of the Chapter 2800, which are the COA regulations, were being updated. So there was a public comment period approximately 10 months ago where the proposed COA regulations were put out for public comment. OPI received a number of comments from non-public schools and other educational stakeholders, and we've been in the process of making revisions to those regulations based upon that input. There are significant substantive changes that have occurred based on the feedback that we've received, so we're really at this point looking at the best ways to be able to integrate all of that feedback into the regulations. And at this point, we don't have a target date for a second public comment period for those regulations, but we will keep you posted on the revision process of the COA regulations. But in the meantime, the existing COA regulations from 2010 still stand. Let's see, the next question, how is the meeting within 10 days of each restraint realistic? We recognize that, in a lot of cases, this may not be a realistic endeavor, but what's important, though, is we're not seeing any documentation that any kinds of IEP meetings or any kinds of meetings are happening for students. So if a student is being restrained 2, 3, 5 times a week, again, you're thinking about these, in terms of the regulations, these are emergency circumstances where a student is in crisis, and there continue not to be documentation where the team of individuals who come together to be able to tweak a behavioral program can demonstrate that they've considered other interventions, have evaluated what's worked and what's not, and designed a new course of action. So, the ideal goal according to the regulations is that within each of the incidents that an IEP meeting is convened within 10 days. Right now, we're at essentially the bottom of that process where we're not seeing any documentation that there's any kind of follow-up meetings to discuss or revise a student's program. So what's important is that, at least non-publics are demonstrating that the kinds of discussions that we know are going on but that are not documented in the system of record get in there in a way to be able to demonstrate that these emergency circumstances, students in these kinds of crises are receiving consideration in terms of modifying the support for them in these instances. Okay, I'm going to skip to the last question. Would a documented student team meeting that includes the parent input found to be compliant, even if not a formal IEP meeting following restraint or seclusion? That's a great question, and I think as we look at if we were able to see that kind of documentation, if we had a sense that relevant participants, whether that's somebody who was part of the restraint, whether that's the child's clinician, were also a part of that meeting, those would be acceptable forms of documentation that demonstrated that the regulation was being adhered to. There's another question, can we get these slides and access to the quality assurance review? Absolutely. So as of the registered participants as of 8 o'clock this morning, that list I already emailed out the slides to that included the quality assurance review form. I'm happy to do it again once we conclude this webinar as well for the actual participants who ended up on the phone. So absolutely, we'll get that out to you. Let's see. It is my understanding that completing and loading an incident form into SEDS was optional. Is this true? What we need to be able to see is evidence that the LEA was notified, that the parent was notified, and also that it's placed within the student's permanent record, which is SEDS, within 24 hours. So it is not optional. Okay, let me just go back and see if there are other questions that we. Okay, so I think. I'm sorry, you can say.
Where do we get a copy of the incident report form quality assurance checklist? The PDF that Edgar sent out this morning and will send out again has a copy of it at the very end of the document. So it's a PDF version. It's not just in the slides, so it's easier to read.
Yep, okay. If there are no other questions, we will move on to the next section. So.